Thank you so much. And I know you have a speaker every year from different areas. I think last year was West Virginia. So it's very nice this year. I am a child of the Brookfield Elm Grove area. My kids are at St. Mary's Visitation just down the road where I went. But of course, I've been familiar with Brookfield Academy my whole life. And I'm well aware of the stellar reputation that the school has. So it's a real honor to be here speaking to all of you. So I'm going to start with a prop. Have you ever had a speaker start with a prop before?
No, this will be the first.
Okay, so this is a tie with the Constitution, part of it, on it, that was gifted to me by a judge. But I never wear it. And true story, I put it on this morning, and then I took it back off. And the reason I never wear it is it just doesn't seem right to me that the Constitution should be on a piece of clothing. And some of the students outside, the first thing they said when they were speaking today was, "We revere the Constitution." It's getting at the same thing. There are very few documents that I would feel this way about, where I would never wear it on a piece of clothing. And, you know, we have to ask the question, why is that? Why do we feel that way about the Constitution? Now, some of you may be thinking, well, Anthony sounds like a bit of a nerd, that's probably why he doesn't do it, but you're all here today listening to the Constitution, listening to a talk on the Constitution, celebrating with these wonderful students outside the Constitution. Why do we do that? And I think it's based in part on a recognition that we have incredible freedom in this country, we have incredible success in this country, we have a wonderful way of life, and intuitively we all kind of know that we owe that to this founding document. And that raises the question of why. What is it in this Constitution? Many countries in the world have constitutions. What is it about our Constitution that has provided this amazing freedom that we enjoy? And that, on the screen there, is my favorite Supreme Court Justice, now deceased, Antonin Scalia. As an Italian lawyer like myself, that's probably why I kind of like him a little bit. And he would go around to schools, high schools, grade schools, colleges, and he would ask this question: what is it about our Constitution that makes the difference? And the answers that he would get were invariably provisions of the Bill of Rights. So people would say freedom of speech, freedom of the press, religious liberty, Second Amendment, right to be free from unreasonable searches and seizures in the Fourth Amendment. And in the typical, colorful Justice Scalia way, his response to that would be, if you think it's our Bill of Rights that makes the difference, you're crazy. He would say every banana republic in the world has a Bill of Rights. In fact, he would point to the USSR, the Soviet Union, and say they had a much more robust Bill of Rights than we do here in the United States. In his view, and in the view of the founders, though that Bill of Rights was just a paper guarantee, parchment guarantee, if power could be centralized in one individual or one entity at the head of the government. For Justice Scalia and for the founders, the genius of the Constitution wasn't simply this Bill of Rights, which is important, of course, but it was the separation of powers, both vertically and horizontally, both between the state and federal governments and between the legislative, executive, and judicial branches that guarantees our freedom. It's that structure that makes the difference. Now we know this, I think, intuitively, that separation of powers preserves freedom. And I'll give you a little anecdote from my own childhood on this. So I was growing up in Elm Grove. I have 3 brothers. And one night my parents leave the house, they go out for dinner, and they leave us 4 boys to our own devices. And of course, being young boys, we start roughhousing, and we break something valuable in the house. Okay, well, my parents return home. My mom's first in the door. She looks at the glass. My dad's first in the door. He looks at the glass. He looks at all of us, and he's about to blow his stack at us. Right? My mom comes in second, and she looks at the glass. She looks at us boys, and then she looks at my father. And she turns to us and she says, "Boys, run." We hightailed it out of there. Now, the point is, I don't think we got disciplined that night. I think we got off scot-free. Now, if my dad had been the only one there, the night would have ended very differently for us. But because power was separated between my parents, he had to make it through my mother if he wanted to act, right? That preserved our liberty. It's the same. It's the same with our committees. It's the same with our boards. I'm sure many of you serve on boards at BA, right? Sometimes we roll our eyes about these committees. There are a lot of meetings, a lot of Zoom calls. Things take a long time to get done, but we know that that helps us make good decisions, right? Those checks and balances. And certainly our founders had the same thing in mind. So I have a quote up here from Federalist 51. In the compound Republic of America, the power surrendered by the people is first divided between two distinct governments, that's the federal government and the states, and then the portion allotted to each subdivided among distinct and separate departments. Those would be our different branches, our legislative, executive, and judicial. Hence, a double security arises to the rights of the people. That's the name of the talk here. The different governments will control each other at the same time that each will be controlled by itself. So the theory here is that if you have this ambition counteracting ambition, it will be very hard for any one governmental entity to exert too much power. That is the genius of the Constitution. So this is what we're going to talk about today. I'll give you a little note on our agenda. I'll talk a little bit about the vertical separation of powers, a little bit about the horizontal separation of powers, and then I'll take questions. So please feel free to come up with some hard ones for me here. Okay, so let's start with the vertical separation of powers. Now, the vertical separation of powers is this notion of federalism. It's one of these topics that, it's a word that gets tossed around. We don't always have a good grasp of what it means. It's just this system of dual sovereignty in the United States where we have a federal government and the state governments sharing in the responsibility of governing. Now to understand this, we have to have a little history. Do any of you know, we have a right here in Wisconsin, a constitutional right to hunt and fish. And many people aren't aware of that, but it's in the Wisconsin Constitution, Article 1, Section 26. Now why do we have a separate constitution in Wisconsin? The reason we have the separate constitution is because Wisconsin is its own sovereign, something that we often forget. The states, as the students outside were talking about, created the Constitution. The states created the federal government, and not the other way around. In theory, if the federal government disappeared today, DC disappeared, Wisconsin would just revert back to its original governance. We would take care of ourselves. We have a governor, we have a legislature, we have a judiciary. And so historically, as you're aware, the 13 British colonies were the original entities here in the United States. They declared independence from British rule in 1776, and at that point they were separate sovereigns, right? They were states, they were united, but not really. We had the Articles of Confederation, which again, as was discussed in the assembly outside, really weren't getting the job done for us. The states were not able to act in unison. They were all acting separately. We had a lack of an ability to tax, which sounds pretty good, but at the time, kind of unhelpful. We couldn't regulate interstate commerce, so we didn't have a national market. There was no unified international diplomacy. So, as you all know, in 1789, these debates led to the U.S. Constitution, which created a stronger federal government while retaining the individual states as separate sovereigns. So for those of you who are more scientifically minded, former Supreme Court Justice Anthony Kennedy had this wonderful turn of phrase where he said the framers split the atom of sovereignty between the states and the federal government. They were very, very careful. So here I have some contemporary images. We've got the snake that's cut up. These are the individual colonies or states. This actually predates the Constitution. Join or die. If we're separate, we're not going to succeed. Same concept here. I think this means return to the golden age, or the return to the age of Saturn. And we've got the individual state pillars, obviously stronger together than we are separately. And boy, Rhode Island is really being run down outside. We see Rhode Island's going to be the last one over here. Now the framers were very, very careful. I know there's a lot of text on this slide. The framers were very careful in setting up this system of federalism. The states would keep their police powers. Okay, police not meaning law enforcement in this context. Police just meaning the general ability to regulate that a sovereign entity has. So the traditional formulation I have up here is that the states could basically regulate anything. Laws promoting the public health, the public safety, the public welfare, and the public morals. And then at the same time we had, very famously, our federal government with enumerated powers only. Federal government could only act, and still today can only act, if it has a specific grant of authority from the states that can be found in the US Constitution. So I have a list of some of those. Many of them are found in Article 1, Section 8. And so it's pretty small, but regulate commerce with foreign nations, immigration, coin money, establish post offices. I mean, they get pretty granular, but they were very specific in what they were willing to allow the federal government to do or to not do. For the remainder of the powers not granted to the federal government, under the 10th Amendment, those powers would go back to the states or the people, or remain with them, I should say, remain with the states or the people. Now, what happens when the state and the federal governments conflict, when they're both regulating in an area that they're able to do? Well, the Supremacy Clause, Article 6, Clause 2, provides that the Constitution is the supreme law of the land. The Constitution overrides any conflicting state law, even state constitutions. So this system, this genius system, provides unity where needed. We now have a federal government that can act on behalf of the states, while retaining the ability of states to be laboratories of democracy. That's another turn of phrase from Justice Brandeis on the US Supreme Court. Laboratories of democracy. Each state can regulate its own local affairs. And I think we kind of forget that nowadays. We're so fortunate to have a unified country and to have this federal government. We forget that these states are still separate sovereigns. So if you say, you know, honey, we're going to move to Vermont, you're not just moving to another city, you're moving to another sovereign entity that might be very, very different from the state that you're in. And that's part of the design. Now, returning to our main theme here of liberty through the separation of powers. Again, under this system, the states remain free from too much federal control, too much of a centralized government, but the federal government can step in if the states begin abusing liberty themselves. We can think of the civil rights movement, for example. We had southern states who were discriminating on the basis of race. The federal government was able to come in and take action. Now, many of you, I'm sure, how many of you are lawyers in the room? Any? Okay, we have one. Christine's a lawyer. So you've all escaped law school, but we are going to take a little bit of, you're going to get a taste for it this morning. I'm going to go through a couple of case studies to give us a better idea of how this works in practice. And as we go through, ask yourself, are these cases decided correctly? Does the federal government really have this authority? Or should it be in the realm of state control? You're going to see that the federal government's authority has grown over the years. You can ask yourself, is that a good thing? Maybe it is. Or is that a bad thing? So I could go with any of the different enumerated powers, but we're going to look at the Interstate Commerce Clause, which I have up here on the screen. Congress shall have power to regulate commerce among the several states. The notion here is we want a national market. If Wisconsin is enacting protectionist legislation for its own citizens, and Florida's doing the same, then our economic system's going to break down, and it's not going to be a good place to do business. So the federal government was given the authority to regulate commerce among the states. And every law school in the country teaches its students this 1824 case of Gibbons versus Ogden. It was sort of one of the landmark cases interpreting this clause. And it involved control over who was going to be able to operate steamboats in the New York harbor. So New York decided it was going to grant a monopoly on these steamboat transportation to Ogden, Sky Ogden. And Gibbons didn't like that. He wanted to run his own steamboats in the New York harbor. And not only that, but he had a federal license to do so. So the question was, who had authority over New York harbor? Was it the New York State, or was it the federal government? And this went all the way up to the United States Supreme Court. And the Supreme Court said, you know what, yes, operation of steamboats across state lines, that's commerce. We're going to count that as commerce. And so under the Supremacy Clause, federal government has the right to decide here. Okay, so this would be an example of a conflict between a state and the federal government vertically. The federal government stepped in and said, no, state, you're acting outside your authority, at least under the supremacy clause in granting this monopoly. So I think that makes sense to most people, okay? But as you'll see over the years, we get to some more controversial cases. So I have here Wickard versus Filburn, 1942. There's Roscoe Filburn. He's a farmer in Ohio. And the federal government had limited the amount of wheat the farmers could grow. Okay, it was trying to stabilize the national wheat market. If there's too much wheat on the market, the supply goes up, and we know that the prices will come down. So they limited the amount of wheat farmers could grow so that farmers were making a good profit on their crops. Well, Roscoe didn't like that. And so he grew a little extra wheat on his farm. He didn't sell it on the national market. Okay, he did not. He used it for feed for his own animals. Okay, so the question was, is that interstate commerce? It's all remaining within Ohio. It's not even leaving his farm. And that went all the way up to the U.S. Supreme Court. The U.S. Supreme Court, in a case that remains controversial today, said, yeah, that's interstate commerce. Yeah, that surprises a lot of people. So what the court said was, look, if Roscoe had not grown that extra wheat, he'd be buying the wheat for his animals on the national market. And not only that, if everyone were a Roscoe Filburn, that small effect would become a big effect. So we're going to count that as interstate commerce. So you can see governmental authority, even though these powers are enumerated, it's starting to expand over time. And good faith lawyers on, all sides disagree on whether that case was correctly decided to this day. Okay, our last Commerce Clause slide, thanks for staying with me, is NFIB versus Sebelius. Okay, this is probably a familiar picture to many of you. President Obama, he was signing into law Obamacare. And a lot of people don't realize this was a major Commerce Clause question. Because a big piece of Obamacare was this idea that the federal government was going to stabilize, not the wheat market, but the national health care market, with the imposition of this individual mandate. Everyone would have to buy health insurance. And if you didn't, you were going to be penalized, just like Roscoe Filburn was penalized for growing too much wheat. The question was, and again, it's a question we should always be asking when we see the federal government or state government doing something, did the federal government actually have the authority to require you to buy health care? Where is that in the Constitution? Well, the federal government pointed to the Interstate Commerce Clause, saying, look, we're trying to stabilize the national health care market. And this went all the way up to the U.S. Supreme Court, and in a split decision, the court decided, no, finally, we're going to put a limit that's too far under the Commerce Clause. And the difference between Wickard and NFIB versus Sebelius was this notion that Filburn was engaging in an activity, whereas Americans not buying healthcare are not engaging in the activity of engaging in commerce, right? They're not purchasing something. And the Supreme Court said, look, you can't regulate failure to engage in commerce. You have to at least be doing something. Now, a little footnote on this, you might remember the individual mandate was upheld under the Constitution. It was a different enumerated power. The court decided that the individual mandate was a tax. It was a tax on your failure to buy health care, so it was upheld under the taxing power. So this is one of those great cases where this decision comes out, and everyone's saying, was Obamacare struck down or was it upheld? And that's basically where the analysis is stopping. But this is actually a major case for the Commerce Clause that's going to have ramifications for years to come, because it set an outer limit on the growth of that clause. All right, I'll mention just one more. This is not a Commerce Clause case, but this is an ongoing case, just to give you an idea that these vertical federalism conflicts are still happening. Okay, so this involves immigration, United States versus Texas. Texas is upset with the way that the federal government is, or is not, depending on your view, regulating immigration. And so it adopted a law that basically gave Texas the authority to remove illegal immigrants from its territory, okay? And they were sued for doing that. So the question is this really state authority, or is this the federal government's job to regulate immigration? okay? And this is still winding its way through the courts. But the point that I want you to keep in mind is not who's right or who's wrong in this dispute, it's this notion that this conflict is part of the design. When we see this happening, you should feel good in some ways, because that fight between the federal and the government and the states, that's what's protecting our liberty. Any questions on vertical federalism before we move on to horizontal?
Are the state constitutions very different, one from the other?
They are, yes. I mean, there are some ways in which they're very similar. We'll talk about one of them, which is separation of powers. Many have legislative, executive, judicial, but there are important differences in the rights that they protect and sometimes the structure of the different branches. And again, this just goes back to that idea that you should put thought into what state you're living in, because the states are different. And you know, Wisconsin does not, Wisconsin, just to go back to that, I love the hunting example, because it's such a clear, there are not many states that protect them. Now maybe you're against hunting, maybe you're in favor of it, but that, you know, might play into your decision. Okay. All right, horizontal separation of powers. Now, I know a lot of you, probably some of what I've already discussed is very familiar to you. You already know about the three branches of government, but I was looking at a statistic, some of you may have heard these types of statistics. In 2022, fewer than half of US adults, is it less than half or fewer than half?
Fewer.
Fewer than half of US adults, 47%, could name all three branches of the government. Okay. So your wonderful children outside, they were already beating over half of US adults. So you should feel very good about the educational decisions you're making. So we are going to go over some of it. Horizontal separation of powers, just this idea of division within a governmental entity. So in creating the federal government, our founders were concerned, as I mentioned, about the concentration of power. I began by talking about how the Bill of Rights is just this paper guarantee, as Scalia would say, unless power is separated. If it's concentrated, the sovereign can ignore it at will. So our founders here in America, it's kind of hard to see, this is America in the distance, they were operating against a monarch, a king, who often acted tyrannically. Right? They would override colonial laws. There was famously taxation without representation. And in this 1775 cartoon, we have the king being pulled by two horses labeled Pride and Obstinacy. And it's pulling him into war with America. And here he is, they're riding over the Magna Carta and the Constitution. Okay, so the notion here is, again, well, they had the Magna Carta, but it wasn't worth much because they had a tyrannical king who could act at will, and sometimes Parliament as well. So what the founders did is they split, famously, our federal government into three branches. Legislative, which passes the law, the executive, which enforces the law, the judicial branch, which interprets the law. And a former Supreme Court, Wisconsin Supreme Court Justice Daniel Kelly, he had a nice way of thinking about this. He would talk about how the legislature deals with the future, what our policy should be. The executive deals with the present, what our law is now and how it should be enforced. And then our judiciary deals with the past and adjudicates what happened. And then, of course, our founders divided power even further horizontally. We have two houses in our Congress, and those houses are of different sizes, staggered terms, very complicated mechanism here, and it of course leads to gridlock. How many of us have complained about how Congress can never get anything done? But that was a feature, not a bug. The founders thought, look, let's err on the side of less legislation and better quality legislation than too many laws. That was the idea. Now, of course, that leads to some interesting, sometimes questionable consequences in modern days, where we see, for example, attempts to use the courts maybe to do what Congress should be doing, or the executive branch issuing a lot of executive orders to do what Congress should be doing. We see these things, but again, part of the system that we've chosen here. No constitution is perfect, as was said outside. All right, just a couple of cases on this. So this is one of the most famous U.S. horizontal separation of powers cases, Youngstown Sheet and Tube Company versus Sawyer. So this case happened in the context of the Korean War, and I really hope that's a picture of the Korean War that I got up there. I'll check on that later.
Okay.
The United Steelworkers Union decided that they were going to go on strike in the middle of the Korean War. And President Truman said, that's a problem, I need the steel. And so he thought about going to Congress and asking for a law allowing him to take control of the mills, or requiring the end of the strike, or something like that. But he decided, hey, that's going to be too time consuming. So what did he do? He seized the steel mills, unilaterally. Okay, so they would continue producing steel. And this goes up to the US Supreme Court, and in a very famous decision, that action was struck down. And the court said, in the framework of our Constitution, the President's power to see that the laws are faithfully executed refutes the idea that he is to be a lawmaker. I think this is a very poignant illustration of the point that I made at the beginning, which is if power had been centralized in the President, we didn't have a Congress, we didn't have a judiciary, your Bill of Rights isn't doing a whole lot of work, because the President's going to seize the steel mill. Who's going to stop him? But because of this division of powers, the system worked exactly as it was supposed to. As soon as that Supreme Court decision came down, Truman gave the mills back. And he was surprised by the decision. Imagine that.
You should read the Constitution.
He should have one of these babies. Now, this, again, as I just want to go to an ongoing dispute so that you know this isn't all history, this is going on today. Learning Resources, Inc. versus Trump. This is a case pending right now at the U.S. Supreme Court. We'll get a decision probably by next summer, I think. And this involves those famous tariffs that President Trump loves, right? What is a tariff? It's just a tax. So he's putting taxes on imports to the United States as a way, in his view, of combating some of these trade imbalances. Okay, so it makes it more expensive to bring goods in. Maybe companies will build here or buy here. And the question that we should be asking, as I mentioned, is does the President have authority to do that? Maybe he does, maybe he doesn't. And what he's relying on for his ability to implement these tariffs is the International Emergency Economic Powers Act. Okay, that law, I'm going to quote here, allows the President to deal with any unusual and extraordinary threat which has its source in whole or substantial part outside the United States, end quote, and then it authorizes him, quote, to regulate importation of property in which any foreign country has an interest. It's a very broad grant of authority, regulate the importation of goods. Now, the President has declared a couple of emergencies. Number one, he views the trade imbalances as an emergency. And then number two, he says there's too much fentanyl and opioids coming into the U.S. So that's another emergency. So I can act. I can impose these tariffs without Congress's approval. Okay, well, this has gone to the U.S. Supreme Court. It is a statutory interpretation case, but it's pretty clear the President is relying on his own executive authority as well in the area of foreign affairs. Hey, I'm the President. It's my job to keep the country safe. So the court's going to decide whether or not this should have been done by Congress or whether it's within the President's authority. And again, people can debate who's right or wrong here, but the conflict is a good thing. The conflict is a sign that the system is working. And then just one last note on the horizontal separation of powers. We, of course, have this at the state level as well. I've been talking about the federal level, but in Wisconsin, we have a legislature, not a Congress. We have a governor, not a president, and we have a state judiciary. Here's our Wisconsin Constitution. Fun fact, this isn't the Wisconsin Constitution. Our original Constitution was lost. So we don't, some might call it a small constitutional crisis, but we'll ignore that. But they never recovered it, is my understanding. But this is a copy of the state constitution, and then here's, of course, our beautiful Capitol building. We're very lucky to have such a beautiful building. So in Wisconsin, we have our own disputes going on about the horizontal separation of powers. I have Evers versus Markline. Groundbreaking case from last term, 2024. very few people probably aware or familiar with it. Okay, so this is a case where the legislature had delegated to an executive branch agency, the Department of Natural Resources, the ability to spend funds for land conservation. But a committee of the legislature the legislature gave to one of its committees the ability to halt the use of those funds if it decided it didn't like how they were being spent. And in 2024, the Wisconsin Supreme Court said that violates the separation of powers. Because once you've given the money to the executive, to the governor, it's his job to spend it. It's his job to enforce it. And a smaller committee of the legislature, rather than the entire legislature itself, can't then, without passing a law, interfere. So again, we see this conflict happening within the states as well. So, in conclusion, my point today was not to insult the Bill of Rights. I love the Bill of Rights. Give a separate talk on the Bill of Rights someday, maybe.
Sure.
But let's not forget, the Bill of Rights was added later as a set of amendments to the Constitution. It was the complicated structure of our government that the framers thought would secure our liberty. So we do have gridlock today, we have conflict, but that is what leads to our freedom, and that freedom is what produces our success. So today, as we celebrate the Constitution, we should celebrate the genius of our founders who had the foresight to divide the authority that was given to our government between the states and the federal government, and then across the governments between the different branches. And before I take any other questions, I just want to thank all of you, because not only for having me here, but that assembly was beautiful. It gives me a lot of hope, because we are not teaching civics as well as we should be in this country. And seeing the kids out there magnificently recite some of our founding principles shows that you all are doing a fantastic job. So thank you. Those are our future leaders out there. So happy to take any questions.
Any questions?
I can tell a story.